Vivian Cronje, who works as a reliever at a Vosloorus Court, has just wrapped up her evidence-in-chief in the Senzo Meyiwa murder trial within a trial. Cronje has been a magistrate since 1996. She has confirmed a document as a confession taken on the 24th of June 2020, stating that she was contacted by a senior prosecutor in October 2020 to take a confession. Cronje says that she saw the accused in handcuffs, that is accused number 2, Bongani Ntanzi. Let's take you live now to Manqoba Mchunu, who has been tracking developments in this trial within a trial. Manqoba, what came out of her evidence-in-chief?
Well, essentially, Maseko, what came out of the evidence is that accused number 2, Bongani Ntanzi, had appeared happy and was more than willing to make a confession to Magistrate Vivian Cronje back in 2020. And this all happened on the 24th of June in 2020 when he had been brought by an officer from the cold case unit to make a statement or a confession as far as the case of Senzo Meyiwa is concerned. And what we understand from Vivian Cronje's evidence is that when he arrived there at that particular court in Boksburg, he had appeared comfortable and he was in fact more than willing to make that particular confession. You recall, of course, Maseko, that this is important because at the very heart of this trial within a trial is whether or not those alleged confessions had been done voluntarily and freely by these accused. They, of course, claim that these were not done lawfully when they were extracted by the police as well as the magistrate. So what Cronje has told this court is that, in fact, Bongani Ntanzi was read his rights just prior to him making that particular confession, and these are rights that are premised on Section 35 of the Constitution that speak to the right to remain silent and not to be compelled to make any incriminating evidence. And she says he had then indicated that he'll want to continue making his statement. She also asked him about whether or not he was pressured into making the statement, and his response was that he had not been pressured or that he had nothing to gain as far as this evidence is concerned. But what is interesting is that this confession, Maseko, was made in front of a lawyer, Bongani Ntanzi's lawyer, who was also present when that confession was made. And of course, the assertion from this evidence is that neither was Ntanzi assaulted or was he forced into making this particular statement. He was asked whether there was any assault that had taken place or if he had any injuries that he had suffered, and his indication was that he had not had any injuries at the time, and that in fact the only injury he had was an injury that he had as a child. So clearly showing that there was no force or coercion as far as that confession is concerned. But take a listen to what Cronje had to say as part of the evidence.
Was asked, did the police or any other person assault or threaten you to make the statement? Answer, no, not at all.
Umbuzo olandelayo ke ngamaphoyisa noma nje noma uyimuphi umuntu ke owakushaya noma owakusabisa ke ukuthi wenze le statement cha naka lutho nje.
Did anyone influence you to make the statement? Answer, no, I decided on my own.
Ingabe ukhona yini umuntu owaba nomthelela ukuthi wena uzokwenza lesi statement lesi cha isinqumo engayithathela mina?
Did anyone encourage you to make the statement? Answer, no.
Khona yini owakugqugquzela ukuthi wenze le statement cha?
Were any promises made to you to persuade you to make the statement? Answer, no.
Ngaba ikhona yini ithembiso ezenziwa kuwena ukuthi ke noma ke ukugqugquzela ukuthi ke wenze statement lesi? Impendulo yathi cha.
Do you expect to derive any benefits from making the statement? Answer, no, not at all.
And Manqoba, we understand that the defense will be given the opportunity for cross-examination only tomorrow.
Well, certainly, Masiko, and this is because it emerged in court, in fact, that there was an audio recording of that particular confession, and this all emerged just before she took the stand, with the state saying that that audio recording will then be made available to the defense. We understand that they only were given that particular audio recording around about tea break, when this matter had broken for tea break around 11 o'clock. And so they had indicated to court, Masiko, that in fact they will need more time to be able to listen to the contents of this particular recording before continuing with their cross-examination. But we know that the defense is going to argue that these confessions were made unlawfully and that there was coercion that was used as far as extracting those confessions is concerned, and that the accused were under duress and that they were assaulted or tortured into making those particular statements. And earlier on, we got to also hear from the defense what it is that they're going to argue when they do get the opportunity. Take a listen to what the defense lawyer for accused 1 and 2 had to say.
That it has been obtained under duress.
Obtained under duress.
Correct.
Mm-hmm.
That the deponent did not sign the statement.
The deponent did not sign the statement before Mrs. Cronje.
Correct.
The deponent did not sign the statement before Mrs. Cronje. Right?
And lastly, my lord, the statement was not made as alleged freely and voluntarily by the deponent.
All right, Manqoba Mchunu live for us in the capital. Thank you.